Okay, so there has been new development in the case against Tyler Robinson. In case you don't know, Tyler Robinson is the guy accused of assassinating conservative activist Charlie Kirk. Now, what are we looking at? So we're in the courtroom where there's another. So a couple days ago there was a proceeding, right? And we're gonna take a look at that. Obviously, we can't see the whole thing. It's like almost 3 hours long, but we could see a little bit of it and just check it out and see this from the whole legal perspective, because we can get look, this video isn't about conspiracy and all that, which we could absolutely get into because there's a whole rabbit hole of conspiracy and stuff, but that's not the purpose of this video. So let's get into it, shall we?
All right, well, let's turn to the matter that's before us. As this is the defense's motion, I will turn to you.
By the way, may I add, Tyler Robinson has yet to be arraigned. For whatever reason, Utah does things a little bit different where, most states, especially California, well, not especially, but as someone who lives in here, I know more so about what goes on in California. Your first appearance before the judge is your arraignment, where you enter guilty, not guilty, no contest, please. Yes, Utah does something a little bit different where, where first appearance is he's given the charges, and then they do preliminary, and then they arraign him, and then after that, anything that needs to be done, and then trial, and then. But yeah, so he has yet to enter not guilty, or no contest pleas. I'm guessing he's gonna enter a no, not guilty. That's typical for most criminal cases. If there's a plea bargain, then maybe, like in this case, the plea bargain would be taking capital punishment off the table, because if convicted, that's absolutely what he faces. So that'd be an example of a plea bargain, the plea guilty to the charges. But if he goes to trial, which is likely, because, well, now then again, he did admit to it, so that could have something to do with, I don't know. I'm not a legal expert. These people obviously know much more about what's likely to happen than I do, but yeah. So let's just get back into it.
Arguments and your request. And just as a heads up, I'm battling a cold, so if I take a drink of my water, it's to spare you from coughing or an overly rough voice.
No problem.
Yes, sir.
Yes, thank you.
Man.
I will be addressing the motion to classify the January 9th motion, kind of taking these in chronological order here. I know this court is kind of drowning in First Amendment briefings, so I don't want to delve too much into that.
It is hot. It is hot around here, I'll tell you.
Certainly, I'm open to answering any questions the court has, but I kind of want to start with just the very base level. We are asking the court to classify this motion and the attachments as private under Rule of Judicial Administration 4-202.04. The reason that we are asking the court to do this fundamentally is because we believe that the release of this motion and the evidence has a reasonable probability of impacting our ability eventually to impanel an impartial jury and for our client to have a reliable penalty phase should that occur.
Look, I hate pausing videos all the time, but oh shit, my chair got stuck in the carpet. Whoops. But I mean, if he's convicted, he's cooked. Alright, if he goes to trial and he gets convicted, he's cooked. He's looking at capital punishment, life imprisonment at a minimum. But that being said, everyone deserves the right to a fair trial, even the most monstrous of people. This guy, if he is the guy who killed Charlie Kirk, then he is an absolute monster, because and that's just coming now. Look, obviously it's easy to say that when as someone who agreed with Charlie on a lot of things and who enjoyed, who liked him, but still, I mean, any reasonable person would be like, no, it's unacceptable to assassinate people just because of words. So he's looking at some serious penalties, like I said, capital punishment, because this is the aggravated. This, honestly, because it's a political assassin, that alone might make things aggravated. That might be a aggravating factor. Like I said, I don't know much about the law, especially in Utah, but I reckon that, because it was a political assassination, that would be an aggravating factor. Let's get back into this.
I want to start kind of with a little bit of a procedural history here. Back in October, November, early in the case, the defense and the prosecution met and conferred about how the government would preserve evidence in this case. And when the government, the prosecution, and any law enforcement agencies sought to conduct testing that might impact the evidence in particular ways, they were to provide us notice. And if we could not come to
Sorry, I could lean back a little bit too much.
We are required to file something with the court to ensure that the testing doesn't move forward. That's what occurred here. In December, on December 22nd, we received notice from the state. They filed a certificate of service for that notice, and they also informed us in the correspondence, essentially, that they were not filing the notice because they were concerned about their ethical considerations under Utah Rule of Professional Conduct 3.6, which basically says we should avoid making public comments that influence a case, and the comments specifically talk about particular evidence that might impact a case, more likely to impact a case.
Yeah, in a case like this, it's extremely hard to keep things under the table because of just what a widespread, well-known case this is so far. Millions of people saw the assassination. Many people have tuned in. It's like this video has 7.1K videos from Fox 9, Minneapolis, St. Paul. Just from this one channel, one video has a lot of views. People are invested in this case, so it's going to be hard to keep things suppressed, private, because people want to know. People want to know the truth, and quite frankly, we all deserve the truth.
We agreed with this. We did try to come to a resolution, but ultimately, at the end of the day, we needed to preserve the issue. So in order to preserve the issue, we had to file something with the court. And honestly, there was a lot of back and forth about whether or not we could file it publicly, how we wanted to do that, because we have the same concern that the state voiced in that initial email. Are we putting something into the public sphere that will inappropriately enter into the minds of potential jurors and impact the case? Ultimately, we decided that we have two obligations. One is to preserve the issue, to ensure our client's right to due process and his right to effective assistance of counsel needed to be preserved. We needed to file this and put the court on notice in a way that this court can make a ruling on it should that become necessary. And I will say, Your Honor, that we continue to work on this issue with the still negotiating it. We are not asking
Was that my end or their end? I don't know.
Because we think we can likely resolve it. It was almost to
I
the
don't
point
think-
where we contemplated potentially asking to withdraw the motion, but of course that doesn't really cure the record issue. So we are here. In addition to that, the other obligation, of course, is to ensure our client receives a fair trial. So we filed a motion to classify. When we filed the motion to classify, we did notify the state, and they took a slightly different position. They basically said, well, now that you filed it, we don't have the same concerns under Rule 3.6. I think those concerns remain. I don't want to talk about the evidence specifically in a public setting, so I'm going to choose my words carefully and maybe read a little bit more than I normally would.
Sure.
But the evidence is important enough. It is important. It is evidence that will be at issue in the case. But it is also in process, which is the whole point of the underlying motion, right? It's in process. There is more to be done. There is more the state wants to do with that evidence. So it is not in a place, in a position where we are going to be arguing about admissibility because it's not done, right? So what we're talking about is releasing preliminary evidence into the public sphere that has the potential to impact jurors. And it is important enough that we are concerned that it will sway people's opinions one way or the other. And I want to make clear that our concern here with selecting an impartial jury, really, it goes both ways, whether the evidence is good for my client or bad for our client, whatever it is, it makes it harder to find impartial jurors if they are entrenched in client's guilt or innocence. Either way.
All right, we're almost done. I don't know how much into this I want to go because
as the defense that will sway the public opinion. We've already told the court we're not fighting this case in the public. We're not trying to sway the public in favor of our client's innocence. That's not what we're doing.
not trying to sway. Look, I could see what she's saying there. But if he's found guilty, then the people will also adjudicate him guilty of said crime, assuming it was a fair and credible trial. And if he was found not guilty, not necessarily innocent, but not guilty of, but, then people are gonna have certain presumptions about that. But obviously First Amendment exists and people have the right to view this trial and, because we all want the truth.
So,
See what the judge has to say about this.
I also want to address one issue that I've seen generally arising in this case, and I think it deserves some comment. There seems to be an idea that flooding the public sphere with information or evidence from this courtroom will somehow dispel conspiracy theories or shift public narrative. That in and of itself is
Interesting how she'd say that.
concerning to the defense. No one should be worried about that. All we should be worried about is protecting what happens in this courtroom. We believe
But we want to know the truth.
preemptively releasing evidence that we
But I guess
need
that's
to
not what this
provide
case
to
is
this
about.
court in order for this court to make an informed decision is just one of those actions, is one of those things that will negatively impact our ability to have a fair proceeding for our client. So we are asking that the motion and the evidence be classified as private, that this court consider our client's unqualified right to a fair trial and a reliable penalty phase should overcome the qualified right of access at this point. We understand things may change. This evidence may come in other ways at other points in the proceedings, like a preliminary hearing or when we actually challenge the admissibility of evidence. But at this preliminary stage, we believe this is the appropriate course to take to protect the proceedings and our clients' rights. Does the court have any questions for me?
Well, I do, but I'm going to wait till all of defense has presented. Is there another attorney that's going to be presented?
Yes, Mr. Burt is going to present on the other motions to classify and the motion to close the hearing in part on April 17th, if the court is prepared to hear that.
All right.
April
I
17th.
want to hear all of it, and then I'll have questions for you all. Thank you, Ms.
Sure.
Visser.
I find it extremely suspicious that they want to close the case, or close the trial. Don't you? Or is that just me? Find it weird that they want to do that. Because... Now that being said, you would if it if it was like I said, I don't want to get too much into the conspiracy, but yeah.
Good morning, Your Honor.
Good morning.
Michael Burt for Mr.
See how long this goes.
I'm going to be addressing the motion to
Oof.
classify what I'll call the camera motion, the motion to restrict electronic media. So there's a motion to classify that motion.
We'll just skip ahead here, and
then there's
I think the ruling is at towards the end, and the gist is they want to classify certain things. So we'll just skip around.
close the select portions of the hearing that is scheduled for April 17th.
And Mr. Burt, just for clarity, would you mind referencing the docket number of these motions? And,
Certainly.
And for Ms. Visser as well.
What that rule doesn't exactly do is tell the court.
Justifies an exception from this rule that the public gains access to.
Who's this?
Thank you. Thank you, Your Honor. As Ms. Uresk suggested, I'm going to address briefly the motion to close the April 17th hearing in part. The docket numbers for the briefing on that are docket number 425, that's the defense's opening motion. Docket 448, that's the state's response. And docket 451, that's the media's opposition. Ms. Visser at the outset said something that I'm sympathetic with. I know the court has a lot of briefing before it on these motions.
And the
she mentioned
defense
that it felt
is
like we
state.
were drowning in a First Amendment briefing. I don't think anyone wants to drown, but if I had to drown in something, I think I would drown in First Amendment briefing. That sounds delightful. The court ultimately needs to make a practical decision about each of these motions in front of it, and that's a tough task. And I want to help the court with that the best that I can. If the court is going to close or seal anything, the court has to make findings, and the court has to explain which interests it's weighing. It also has to do an important thing in determining that the restriction it's imposing on public access is the narrowest possible way of protecting the countervailing interests in favor of secrecy. So that's tough. The court's been through that several times already, including with the motion to disqualify and the hearing there. How do we identify an interest that we may believe justifies an exception from this rule that the public gains access to these proceedings? And then how do I make that as narrow as possible to ensure that if that interest needs to be protected?
So basically, it's talking about necessity for public access and all that stuff. I don't know. Let's just skip ahead to the I think this is the ruling.
Docket 285. Defendant's motion to classify, motion to exclude. Docket 3. I commend the parties for their diligence.
All right, here we go. Here's where we need to go.
And their arguments, as well as the quality of briefing that was done on this issue. And so the court is going to issue its ruling on what is requested and what is before the court. Before the court are three motions to classify court records. Defendant's motion to classify as private motion filed January 9th with exhibits. Defendant's, and which is docket 285. Defendant's motion to classify, motion to exclude, docket 310. And defendant's motion to classify reply in support of motion to exclude, docket 400. The public has a presumptive right to access court records. Open court records assist in educating the public about the workings of government. The public, docket 285. It's defendant's and which is filed court and briefing that was done, and their arguments as well as the quality of briefing that was done on this issue. Conclusions about specific court records. Defendant does not provide any specific its right to a fair trial. A court may consider any relevant factor, interest, or policy in favor of and opposition to closure and determine as private because it addresses evidence that has not yet to protect the interest, whether to classify or close all or part of a court record. In making its determination, a court must make findings and conclusions about specific court records, identify and balance the interests favoring opening and closing the record, and, if the record is ordered closed, determine that there are no reasonable alternatives to closure sufficient to protect the interests favoring closure. With this legal framework in mind, the court now turns to the pending motions to classify. And as it relates to defendant's motion to classify as private motion filed January 9th with exhibits docket 285. Defendant seeks to classify a motion filed on January 9th, 2026 as private.
Like the video for granted, subscribe for denied.
Because it addresses evidence that has not yet been found to be admissible, and it is of a nature that could easily taint potential jurors. If the court denies his motion to classify, defendant requests an opportunity to file.
This is not, he didn't make his ruling yet.
That redacts the attached exhibits and details from the exhibit discussed in the motion. Defendant does not provide any specificity explaining why the potential evidence discussed in the underlying motion is of such nature that its disclosure could taint the jury pool. The potential evidence discussed in the motion is technical and discusses the process of scientific and forensic testing of physical evidence. It does not contain any obvious private or inflammatory information. And while the evidence has not been admitted at trial, there is no pending motion to exclude it. In balance, defendant has not provided a sufficient basis for the court to find that the interests favoring closure outweigh the interests favoring an open proceeding and the presumptive right to access. Moreover, as the Utah Supreme Court recognized, even in highly publicized cases, a defendant's right to a fair trial can be protected through the regular, time-honored process for selecting jurors, like enlarging the veneer of potential jurors, utilizing a detailed juror questionnaire, and conducting a thorough voir dire of potential jurors. Defendant's request to classify the motion filed on January 9th, 2026 is respectfully denied.
Denied.
As it relates to
Better
the
subscribe.
motion to exclude docket 310. Defendant seeks to classify his motion to exclude cameras from the courtroom.
Oh, right, there's more than one motion.
Files a litany of unfairly prejudicial and oftentimes inaccurate electronic media interviews, comments, and photographs. Furthermore, the motion references court filings that are classified as private and references the publication of private information of individuals involved in this case, allegedly in violation of law. Defendant does not provide any citations to the underlying motion to aid the court in identifying the potentially private information. The court is sensitive to the amount of pretrial publicity generated by this case, including an extensive amount of public commentary and inaccurate or conspiratorial descriptions of alleged evidence supporting or negating defendant's guilt. A substantial amount of this pretrial publicity is organized and memorialized into defendant's motion. Because the references to pretrial publicity are, by their very nature, already contained in the public arena, interests favoring closure are greatly diminished. And this citing to State v. Algier. The public already has access to the majority of the information contained in the motion. Upon balancing the interests at play, the court determines that defendant has not shown that the interests favoring closure outweigh the interests favoring access to the record. With the exception of the potentially private information referenced in the motion to classify, the court orders defendant to file a version of his motion to exclude cameras referencing docket 305 that redacts private information referenced but not specifically cited in his motion to classify. The redacted versions of the motion to exclude cameras must be filed with the court by the end of business on March 30th, 2026. If no redacted motion is filed by that time, the court will reclassify docket 305 as public. If a redacted motion is filed, the court will maintain the private classification on docket 305. Accordingly, defendant's motion is granted in part and denied in part. Finally,
So that means you both have to subscribe and like the video. You heard him. It's a court order. Failure to do so you will be found in direct criminal contempt. 30 days in the county jail.
turning to the defendant's motion to classify, reply, docket 400. Defendant seeks to classify as private his reply memorandum in support of...
Let's see. I think that's a good stop. So
cameras.
a lot of it had something to do with motions of suppressing information, classifying, redacting. Ugh, great. More redaction. But, you know, it is what it is, so I guess I'll keep you posted. I'll let you know if there's anything new comes up and like that. Yeah, I'll catch you on another one. Alright, peace.